Hello and welcome to my video podcast Navigating Commercial Disputes. I'm Payal Chawla and I'm delighted to bring you this series in collaborations with Bar and Bench. Through this podcast, I aim to demystify complex commercial legal issues for lawyers, law students, and legal enthusiasts alike. The recommendations in the 246 Law Commission report were aimed at moving India from aspiration to architecture, to make India an international arbitration destination. India possessed the fundamental ingredients: a robust common law system, a skilled pool of lawyers and arbitrators, an English-speaking workforce, and a strong body of commercial jurisprudence. Coupled with the liberalization of our economy and the growing integration of Indian businesses into global markets, the stage was set for us to join the elite arbitral seats like London, Paris, and Singapore. A thriving arbitration ecosystem would mean more opportunities for Indian lawyers, greater inflow of legal work, and consequently, revenue in our country, and importantly, a reduction in the burden on our overworked courts. In short, arbitration was conceived as both an economic and institutional reform. Parliament acted swiftly. The landmark 2015 amendments came into force on 23rd October 2015. Key reforms included strengthening our tribunal powers for interim relief, limiting court interference under Section 34 and 36, notably by removing automatic stays, and introducing strict timelines. Together, they were unmistakable signals that India was intended to be arbitration friendly. Today, 8 years on, despite 30 arbitral institutes, one of which is the IIAC, which was created under the aegis of the government, and a dedicated arbitration bar, the vision is yet to be fully materialized. On a related subject is the entry of foreign law firms into India. The UK-India Free Trade Agreement negotiations have been recently concluded and are awaiting ratification for approval. To discuss all these issues, I have a very distinguished guest on my show, Lord Peter Goldsmith. Lord Goldsmith is the chair of the House of Lords International Agreements Committee, which is scrutinizing the UK-India FTA. He is a prominent barrister and was the former Attorney General for England and Wales. He is currently the co-managing partner and chair of European and Asian litigation at Debevoise and Plimpton. He continues to appear in major arbitrations and commercial disputes globally. He is not only a major voice in arbitration, but is also one of India's strongest proponents. His wise counsel on this issue would be invaluable to us. Welcome, sir. I'm so delighted to have you on the show.
I'm very pleased to be here. Thank you.
Sir, tell me in general terms, if a country had to become an international arbitration hub, what would they need to do?
You need to do quite a lot. You have to have a judiciary and court system which protects and is in favour of arbitration, because it'll be the place where awards are challenged. You need to have the facilities so that people can come and do arbitration, hearing centres, or at least places like hotels where hearings can take place. You need to have an active legal profession and a number of other things. I'll mention one in one moment, but the Chartered Institute of Arbitrators produced a list at the time of its centenary of the things you needed in order to become a hub for arbitration. And those are some of them that I've mentioned already. But the one I do want to mention is who the lawyers are who are allowed to appear in the arbitration. I explained that, but I think it's something we want to talk about, don't we? That because companies, clients, whether they're individuals, when they go to arbitration, they want to have the lawyers that they trust.
That's right.
If it's international especially, they need to have the lawyers they trust. So if the country where the arbitration is taking place doesn't allow them to have their own lawyers, that's a problem, and they won't choose that country. It's as simple as that, I think.
That you make a very interesting point, but tell me, there is hypothetically, there's an English client, there's an Indian client, and the choice of law is Indian. What would be the motivation to have an English barrister come in? Would they be adept at Indian law?
Let's be clear about this. In commercial areas, there's not a huge difference actually between English and Indian law, because Indian law has its roots in English common law.
That's true.
Often you do it by co-counselling, which is a very good idea, to have local Indian lawyers working with English barristers or English solicitors. But I think the key point is this: if you're talking about choice, and arbitration is about choice, it's all about the parties choosing who they want to decide the case. And if the parties can choose, well, they won't choose a place where they can't actually have their own lawyers representing them for their case. They may be very happy with the lawyers in that country, and that's why co-counselling may work very, very well. But if you have to choose between, let's be blunt about it, India and Singapore.
Right.
Singapore, which is also a common law country. In Singapore and indeed in Hong Kong, English lawyers can do arbitrations. And so the clients, the company would choose that. Would it choose India? It would love to come to India. I love to come to India. But if the company couldn't have the lawyers it trusted to do its case, then I think they would not choose India as a hub, not choose India as the seat. And if India wants to become the hub for international arbitration, something which I very strongly support,
right,
then that's the key issue I think that needs to be grappled with. Not talking about the courts, not talking about people setting up practice, opening firms, talking about the right of people to come and represent their client in front of an arbitration.
Am I correct to assume that in England there is no bar on a lawyer coming to practice even English law in an arbitration?
Absolutely right. I mean, England is completely free. You can come. You can even set up a practice. You can, as long as you don't call yourself an English solicitor, you can set up in Mayfair or Birmingham, wherever you want to be, and open an office and take clients. English law, any law you want. So England is completely free. And that's one of the things I think is also, from the point of view of reciprocity, there are even Indian lawyers who appear before the English courts. That's possible too. You have to go through some procedures. So yes.
For arbitration, even if I were not registered to practice law and I didn't have an English degree, I could represent a client even if there was English law.
Yes, yes.
So, and this is an interesting thing for us to think about.
Yes.
Hypothetically, you are going to, you're drafting a contract. I know you don't do that, but if you were, and you had to choose a seat for arbitration, what are the couple of things, apart from the fact that English lawyers could, or your firm could represent, what is it that you would fundamentally look for to pick India as a seat?
The first thing,
or not India, any seat.
Any seat. No, it's a very good question. The first thing I would look for is what is the attitude of the courts to litigate, to arbitration, because the courts play an important role. They can slow arbitration down. They can set aside the awards that are made. They can intervene. So you want to know, is this an arbitration-friendly jurisdiction?
Right.
Is it one that's going to interfere and not allow you to proceed with the arbitration the way you intended to? That would be something that if I were drafting a contract or I was advising my corporate colleagues about drafting a contract, that's what I'd want to look at particularly.
Right.
There was a time when India was very much not arbitration-friendly. We all know the decisions. I think we're going through that stage, which is very good, but it's important to keep a very careful eye on that.
Right. What about third-party funding?
That's something which is perfectly possible in England, of course. And the truth is that people who want to bring cases often can't afford to do so. I'm not a great fan of third-party funding because I think it does give rise to some difficulties, but I fully recognise that sometimes cases cannot be brought unless people can support them financially, and therefore justice can't be done. So I don't see why that shouldn't be possible. It may need to be regulated, but that's fine. It can be regulated, but so long as it's regulated in a way which means that people can get access to justice, they can actually employ lawyers with the help of someone who's funding them in order that they can bring their case or defend their case.
Right. So, and there are jurisdictions that permit lawyers to get involved with third-party funding.
Yes,
Is that
yes.
something that you support, or you feel that lawyers should completely stay out of, or the third category that it's regulated and it should be permitted?
I'm a little bit old-fashioned in that this is not the way I've been brought up. I don't terribly like lawyers having an interest in the outcome. I worry that may distort their judgment. But the real situation, one has to recognise that it often has to happen. And if the result is that a client can get representation that otherwise he couldn't, I think it should be allowed. We do it. My firm, we do it. We get involved. We will take a particular part of the involvement in it, recognising that to some extent our own money is at stake, and the cases get brought which otherwise wouldn't. That's the reality.
And that would be in the domain of contingency fees, or what they're called is conditional fees?
There's different conditional fees, which is we don't do contingency fees, we do conditional fees, which means that we will charge a low amount, perhaps sometimes even nothing, but a low amount. But if we succeed, then we will have a fee, an increased fee from the client.
So it would be something in a blend of contingency fee and value billing?
Yes.
One of the things that bothers me about foreign lawyers coming to India, and by the way, I strongly promote it, what I'm concerned about a little bit is this issue of lawyers on one side being permitted to have contingency fee, conditional fee, value billing, versus Indian lawyers that we are not permitted to charge any of these. So if the market was to open up, you would have a situation where Indian lawyers are charging on an hourly basis, and no matter how many hours you put in a large value transaction, you would never be at par with an international lawyer. So it concerns me that if they came in, you would have them gobble up the practice, most practices here in India. It is something that is similar to what happened with the consulting firms. So is this something that you promote for India, that we should open it up?
Look, I think there's a difference between what we've been talking about until now,
right,
which is the ability to run and appear in arbitrations,
right,
which doesn't involve gobbling up at all. It involves actually doing the cases and establishing practices. That, I think, is a different issue. I think I recognise that one wants to look at that quite carefully and slowly. But at the end of the day, India is a very strong country. It's got a wonderful legal profession. I have huge admiration for the judges and for the lawyers,
right,
in those circumstances. I'm quite confident that they'll be able to, succeed even if there's foreign competition in town.
And the reason I was asking you this question, to open the legal sector in a phase-wise manner. The first phase would be to open the practice to having foreign lawyers come in for arbitration. And in phase 2, the permissions could be granted to set up businesses here. Do you think it would be prudent for us to begin to think in phase 1 for phase 2? Because hypothetically, let's see a situation, you're representing an English client, have the ability to charge contingency fees or conditional fees, and I'm charging only on an hourly basis. Would that not create a non-level playing field for us?
I don't think so, because I think that from the client's point of view, the client wants to be represented well.
Right.
And I would hope the English lawyers or American, whoever it may be, would do that. But equally, on the other side, the Indian lawyers would do it well. So I think that's a level playing field already, or can be, as long as there's, the right lawyers have been chosen by the client. Sometimes, in some cases, the lawyers are uneven, but that happens in all circumstances. I don't think the fee arrangements really affect that at all.
So something that you had mentioned earlier about the competence of Indian lawyers and judges. So clearly there is a large pool of very good talent that's available in India. There is a pool of good arbitrators.
Yes.
The 2015 amendments were designed to make India into an international arbitration seat. There is a proficiency in the English language.
Yes.
There is indigenous jurisprudence that is built.
Yes.
What is stopping us from getting a seat at the table with the other international arbitration hubs?
Well, I've told you one reason for it, I'm afraid, which is the ability of foreign lawyers to come. It's very uncertain at the moment whether they're allowed to do so. And I think that there needs to be certainty. But if you have a client in New York or in Italy or in London, and they're making an agreement with an Indian company, and the question arises, how do we resolve any disputes? Let's use arbitration, but where will the arbitration be? And at the moment, people will worry about coming to India because they will not be sure that their own lawyers will be able to help them, and they'll be forced, therefore, to arbitrate disputes without that help. And they've got other choices. They will vote with their feet. And that's why I think that's one of the big problems. India has helped to deal with the other problem about arbitration. Are the courts going to interfere too much? Will they grant injunctions? Will they not allow people actually to proceed with them? Will they set aside awards? That's also very important. But the ability of the lawyers to act, if you think that it's the lawyers who are advising the clients what they should put in their contracts, is important.
I agree with you about that. And it's not just selfishness that's driving it. Because if you have a trusted relationship with a client, it's pretty much like going to your own doctor.
Exactly.
And you're not going to choose a seat of arbitration unless that trusted person can be part of it.
Absolutely.
So I agree with you completely on this issue. Now I want to veer a little bit outside because you are the chair of the committee of the House of Lords on international agreements.
Yes.
And therefore you're overseeing the process for ratification of the FTA that India and UK are going to sign. I went through the FTA and I saw that it deals with services. But would that encompass legal services?
Well, you're quite right, first of all, that I am the chairman of the House of Lords International Agreements Committee. We examine treaties, we debate them, we issue reports whether they should be ratified. And the UK-India FTA is one we have on our desk at the moment. Indeed, I held an evidence session just last night, and we're having evidence sessions over the next few weeks until we get to the time for a report. There is a call for evidence on our website which can be seen. We will look at services particularly towards the end of October, because there's a big gap in the agreement as it's been entered into. It does not deal, for example, with professional services, which is something that people have really talked about for a long time. Obviously, the decision must have been it was a bit too difficult, but there are possibilities under the agreement to move forward. But yes, we will be looking at that, and we will be looking particularly at the area of services in the next few weeks.
And so are you hopeful that the legal services will be part of the FTA, or that's going to be kept out for the moment?
It's not there at the moment, except in the sense that there's the mechanism which really encourages the regulators from the two countries to talk to each other to reach some sort of agreement. So there's the possibility, and I know some work is being done on this, for discussions between Bar Council of India, Law Society of England and Wales, Bar Council of England, really to see if we can come up with some sort of arrangements in relation to that. And I would encourage them to talk.
And the FTA, I went through the dispute resolution clause in the FTA, and I did not see an arbitration clause there. So what would your advice be on future of FTAs, BITs, and using these to develop India into an arbitration seat? Is there scope, you think?
I think this is to do more with protection of foreign investors. I'm a proponent of ISDS, of having investor-state dispute resolution systems in FTAs or in other cooperation agreements, so that you can actually resolve your dispute. Once upon a time, my country, the British, used to resolve them, I'm afraid, by sending gunboats, which was not a very attractive thing to do, but that's the way we used to do it. So I think that's worthwhile. And people have been against this, including in India. I think wrongly. I think there are problems about it which can be solved. But I think that's something which ought to happen. And arbitration is a good way of doing it, so long as you get the right system and you have the right cases able to come through that process.
So there is a thought process that third-party funding is a bit like trafficking. And I know that in England and Wales, you've done away with the archaic principles of champity and maintenance. We haven't legislatively done away with it, though there is a Delhi High Court decision that permitted third-party funding. But we are yet to see a decision from either the Supreme Court or an act on it. I think in England and Wales, you've done away with it in 1967.
I can't remember the year, but definitely it's got long gone.
And the Law Commission had a very interesting take on it. The Law Commission had said, if I can quote, they described maintenance and champity as dead letters and no more useless lumber than ought to be discarded in practice.
Well, that says it all, doesn't it? We don't believe it's right. It was a very old principle and very archaic idea. as you say, the thought was that people would be trafficking in litigation, going and buying up cases. But actually, I'm not even sure that's such a terrible thing. The fact is, if you want people, your citizens, to have access to justice, you have to find a way that they can fund it. It's no use saying, as somebody used to say, the law is open to all, like the Ritz Hotel or like the Oberoi Hotel or the Taj, I don't know which you'd use here. The truth is, yes, that's fine. Of course you can go to the Ritz Hotel so long as you can pay. And
Right.
that isn't true. India has wonderfully provided through public interest litigation so that you can actually get access to the Supreme Court. That's a brilliant innovation. But for most things, it's not possible to do that. And I think that to say, oh, you can't be supported by a third party who's prepared to fund you in return for some of the benefit that you'll get from the litigation, that's a wrong thing to do. So maintenance of championship, definitely out the door, dead and buried, into the cemetery with them. That would be my advice.
And also the other thing that, would you be open to the idea that the third party funder could take a percentage of what comes, like they do in the United
Yes.
States? Or would it just be the cost of funding plus interest?
It'd have to be more than cost of funding plus interest, because that's what a bank does, and banks can do that already. The funders have to have some interest that gives them an incentive to fund it, because litigation is expensive.
Right,
and if
it is.
they're putting their money at risk, which they won't get back if they lose, they've got to have an incentive. So, like all businesses, you have to pay something for that. So, whether it's an interest through a piece of the action, if you like,
Right.
part of the damages or part of the award that you get, or through an uplift on the fees. The English way is really an uplift on the fees. You get your fees, hourly fees, plus 50%, could be up to 100%.
Okay.
But then at least that's how the funder gets rewarded. Or it could be a proportion of the damages, but that's contingent fees, which the Americans do, which we don't really allow in England to that extent. But the principle is, to some extent, is the same.
This takes me to a related issue. On the grant of damages and the grant of interest, should India now, given the fact that we're moving towards becoming a more mature, litigious country, should we not be moving to a freer jurisprudence on the grant of damages and interest, and move away from this country which is looking at each of these as a usury principle?
Well, I don't think that should be so. I can't pretend to be an expert in damages under Indian law, though I do possess a book on it, which a very good friend and colleague actually partly wrote, so I have it in my home. But I don't see why you shouldn't look at damages in a realistic economic way. If somebody has caused an injury through breach of contract or tort to somebody else, you should put them back in the position they should be in.
Right.
And you can't do that without paying interest, without paying some additional compensation for the fact that for a long time they have been out of their money. So I don't see that as usury at all. I see that as just fair compensation for what somebody's actually lost.
Also because the cost of money today versus the cost of money tomorrow, those can be vastly different.
Absolutely, absolutely.
Right.
It's exactly so. What are you going to do? You have to compensate for that. Otherwise the wrongdoer is getting away with it.
And incentivized
Yes.
to continue to prolong the wrong.
Yes.
Right.
Yes, you're right. Absolutely right.
So I want to thank you for being on the show. It's been an absolute honor.
Well, I've been very pleased to be here. I'm always pleased to be in India, and I'm very pleased to have been here and to talk to you. Such an interesting discussion. Thank you.
Thank you. That concludes today's episode of Navigating Commercial Disputes. Stay tuned for more insightful conversations on legal issues that matter most.